Good morning, student. In a last lecture, we know about the assessment year, previous year, and assessee. In this lecture, we know about the residential status of an assessee. Residential status of an assessee determines the scope of chargeability of his income. Determination of the residential status of an assessee is important for deciding the scope of total income chargeable to tax because the tax incidence of an assessee depends upon his residential status. As per the Income Tax Act, residential status of an assessee decides the chargeability of foreign income. Hence, determination of residential status of an assessee during the previous year is important. At the time of determination of residential status, some questions arises such as whether an income earned by a foreign national in India or abroad is taxable in India, and second, whether an income accrued to an individual outside India is taxable in India. Such questions can be answered in correct manners on the basis of residential status of a person rather than the citizenship. A person classified as individual and HUF, that is Hindu Undivided Family, and company, association of person, firm, local authority, and artificial juridical person. For classification of residential status of an individual classify residential status first categorized as resident in India and second non-resident in India. Resident individual may further categorized as ordinary resident in India and non-ordinary resident in India. When other person, that is company, association of person, firm, local authorities, or artificial juridical person classifies or categorized residential status of these are resident and non-resident. They are not classified further such as person or individual or HUF, that is ordinary resident in India and non-ordinary resident in India. For considering the residential status of an person, some general points to be considered. So, for first, residential status of a person is determined in respect of each previous year. Second, citizenship and residential status are two different concepts. And third, a person can have same residential status in more than one country. These are the points which are considered the residential status of a person or an assessee. First, in this lecture, we know the residential status of an individual. Individual residential status classify as resident and non-resident. For resident of a person, there are two basic conditions as per the Income Tax Act. First is he is in India in previous year for a period of 182 days or more as per the section 6(1)(a) of Income Tax Act. See, first condition for resident in India for individual is 182 days. He is reside in India for a period of 182 days. And second condition, or he is in India for period of 60 days or more during the previous year and for 365 days or more day during 4 previous year immediately preceding the relevant previous year. This is the second basic condition under Section Income Tax Act 6(1)(c) as per the Income Tax Act for residential status of an individual. If an individual is non-resident, for that this condition is necessary. An assessee who is not satisfied Section 6(1) shall be treated as non-resident in India for the relevant previous year. See, this is the problem relating to the determination of residential status of an assessee. Find residential status of Mr. Jack. Mr. Jack came to India during the previous year 2018-19. During the previous year, he stayed in India for, in first case, 50 days and in second case, 183 days. Determine his residential status for assessment year 2019-20. See, this is the answer for this problem. In first case, Mr. Jack reside in India 50 days. Mr. Jack reside in India in first case only 50 days. As per basic conditions of India, second condition for this first case apply. He is in India for a period of 60 days or more during the previous year. If Mr. Jack reside in India 60 days or more in the previous year, he is resident in India. He is resident in India. But Mr. Jack reside in India in first case only 50 days, and so he does not satisfy any of the condition of Section 6(1). Therefore, he is non-resident in India. In second case, he reside in India 183 days during the previous year 2018-19. He satisfy one of the conditions specified in Section 6(1)(a). This is the Section 6(1)(a). Basic condition is he is in India in the previous year for a period of 182 days or more as per Section 6(1)(a). This basic condition is fulfilled. He became a resident in India. In this case, he resides in India 183 days during the previous year, and that's for he satisfy one of the conditions specified in Section 6(1)(a). Therefore, he is resident in India. This is the problem relating to residential status of Mr. Jack. Okay. Thank you.